Hi everybody, this is a recording of the material that we were to cover for the week of January 19th, but did not hold formal live class because of Martin Luther King Day. So I am going to record that material here for you all. Chapters 11 and 12 is what we are going to cover, and Chapter 11 goes over damages. So we have so far gone over the entire civil litigation process, and we've spoken about damages here and there, but this is where we get into the logistics of what it means for a plaintiff to bring a civil lawsuit and to pursue those damages, because plaintiffs bring lawsuits for many different reasons, but usually the reason is almost always to obtain some sort of monetary compensation for an injury that is incurred. Damages are the injury that the plaintiff suffers as a result of the defendant's conduct. Courts will not compensate a victim or a plaintiff unless some sort of documentable harm has been done. This harm can be in the form of physical damages or injuries, emotional, or both, but it has to exist in one form or another. This is something I often mention when I'm trying to choose jurors, that the purpose of tort law or civil law is to provide a peaceful resolution for conflicts, rather than having people resort to potentially violent self-help. We don't want people duking it out in the streets after every car wreck that happens. So this is what we have at our disposal, is the award of damages. Compensatory damages, those are the most common in negligence cases. As the name suggests, compensatory damages are designed to compensate the victim for the tortfeasor's negligence or conduct. And the policy behind compensatory damages is, quote, to make the plaintiff whole, end quote. That's what we say in tort law, is to make the plaintiff whole. What does this mean? We want to compensate the plaintiff for his injuries so that he is virtually in the same position that he was in before his injuries took place. Now, in reality, that cannot always happen. Really, money cannot take the place of all injuries. No amount of money could possibly compensate an active, healthy adult that is now rendered paraplegic because of a car accident, or a patient that is brain damaged because of excessive anesthesia by a doctor. These plaintiffs, they're never going to be put back in their pre-injury position. And while money damages may seem an inadequate response to these injuries, they can certainly help, right? A paraplegic with a $2 million trust fund is going to be a whole lot better off than he would have been without that money. There are different types of compensatory damages as well, so they're further broken down into general damages and special damages. General damages are damages that naturally result from the harm that's caused by the defendant's actions. So, for example, in a car accident case, after being physically injured, the plaintiff may suffer some pain and suffering as a result of his injuries. Pain and suffering can cover a lot of ground, though. It can include physical pain from the impact of the accident, but it could also include ongoing pain from a wound or long-term discomfort from a permanent condition such as a limp or a weakened back. It can also include the pain of medical procedures such as the surgery or physical therapy used to treat those injuries. It also includes many types of mental suffering from the consequences of the injuries, such as humiliation, anguish, embarrassment, all of those suffered from living with permanent disfigurement, the frustration of dealing with disability that's caused by an injury, fright that's associated with a traumatic accident, or depression that's induced by these injuries. So pain and suffering is really a catch-all term. It can encompass almost any kind of subjective reaction to the accident and or its consequences. Now, because of the subjective nature of the feelings and perceptions that are involved in pain and suffering, there's really no scale or mathematical process that the jurors can use to reach a dollar amount, dollar figure to compensate the plaintiff for them. They just need to simply pick a number based on their sense of their severity of the loss. The jurors can take into account the evidence, or they should take into account the evidence that bears on the nature of the injuries, the certainty of future pain of the plaintiff, severity and or likely duration of the injuries as well. In addition to general damages, there are also special damages under compensatory damages. And special damages are compensatory damages that are specific to a particular plaintiff. So again, special, specific. For instance, lost wages and medical expenses, those are examples of special damages. They're specific to a particular plaintiff. Usually special damages have to be specifically pled and proven in the pleadings in order to be able to collect those. Another name used for special damages you guys might hear are consequential damages. So they are as a consequence of the injuries that the plaintiff incurred. Plaintiff is entitled to compensation for all medical costs of diagnosing and treating the injuries, such as doctor, hospital bills, medicines, rehab therapy, special therapeutic equipment that they might need, ongoing nursing care. These services are incurred by the plaintiff to cope with the consequences of the accident, and their costs should be shifted to the defendant who has caused their injury. Lost earnings refers to the earnings lost between the time of the injury and the time of trial. There's also future medical expenses and future earning capacity. Those are a little bit more difficult to gauge, however, but they are both compensable. The jury is going to have to determine an approximation of these damages based on current medical bills and earnings of the plaintiff. The plaintiff is going to put on evidence of what his future medical expenses should be, and the jury has to attach those sums to these future expenses based on that evidence that the plaintiff presents. For future wages, the jury will have to determine how long the plaintiff would have worked had he not been injured, depending on the type of work he did, his life expectancy, his state of health before the injuries, and assessing these damages really are almost a shot in the dark. But like we said before, it's just a subjective number that the jury has to come up with, an approximation based on the evidence that the plaintiff does put out there. So we know that the standard of proof in civil cases we've talked about when we're proving liability is by a preponderance of the evidence, right? So the question here is, what is the standard of proof in civil cases when proving damages? It's the same, right? Remember that for many civil wrongs, damages is an element. So when you're making a prima facie case, you have to prove up all of your elements by the same standard of proof, by a preponderance of the evidence. So you can't just waltz into the courtroom and expect to receive money damages on behalf of your client if you don't have that evidence, that proof to back it up. So you bring in your property damage bills, your medical bills, tax returns, affidavits, rental bills, whatever proof you have that you are entitled to this money that you're asking the jury for. So even those subjective amounts that we were just looking at for future medical expenses or future pain and suffering, future lost wages, yes, they are subjective. However, they are still going to be based on some sort of objective evidence that the plaintiff has to present to the trier of fact, which is normally the jury. Now, one effective and powerful way to present your client's damages at trial or a deposition for settlement purposes is to present a day in the life video. I don't know if you guys have seen these or know what they are, but basically what you're doing is you are recreating a typical day that your client goes through enduring the pain and suffering that is a consequence of his or her injuries that was caused by the defendant. So we want to come up with a way to relay this information to the opposing side or to the jury. And like I said, that's a great way because you can present these damages on paper all day long, but they are really not going to have the same effect that a video is going to have, that somebody actually seeing what your client has to go through. Like I said, it's very, very effective. It's very, very powerful. And I have here, let me see if this will work. I'm going to try and show you guys a video. I don't know how this is going to work on a recording, so we'll see. Okay. We'll see if you guys are able to follow this at home on the recording, but it is a video of a personal injury plaintiff.
You have had to suffer what no one should have to endure. This has been a horrible experience. The defendant has left you with pain that may last the rest of your life. Your strength, range of motion, and mobility may never return to normal. No doubt a part of this awful feeling is that these injuries didn't have to happen. It wasn't an accident. It was foreseeable and preventable. Your attorney believes in you and your case, but the problem is how to convey to the defendant the misery you live with every day, how to express emotions that so far have been lost in a series of depositions, interrogatories, expert reports, medical papers, and so forth. You are just a name on a piece of paper. Just a name. Your attorney believes that the investment in an image resources documentary about your case will help to communicate these emotions. The defendant will much better understand why they are responsible and what you have suffered. Image Resources is a national leader in producing effective settlement documentaries. Why should you make this investment? Your case is made up of liability and damages. The liability is why the defendant is responsible. The damages are what have been taken from you. The economic damages are mainly financial calculations: lost wages, medical expenses, loss of household services, property loss, and so forth. The non-economic damages are the intangible losses of the case. These include that pain you wake up with every morning.
Okay, and I did forget to turn off my mic, so hopefully there wasn't too much feedback or you guys were able to watch the beginning of that video. And it is an advertisement. There are companies obviously out there that put these videos together, but I thought it was a good compilation of, it shows you guys how they put together the day in the life videos, and then also it explains somewhat how important showing or conveying the damages to the other side is, which is what we're talking about after all. So day in the life video, like I said, very, very powerful stuff. You could show the other side what it is that your client has been going through as a result of their client's negligence or their conduct. So it is a very powerful evidentiary tool. So how is it that you're going to prove your client's damages, namely property losses here on the slide? There's a couple different ways. If the property damage was repaired, then you could present those bills. If the property damage couldn't be repaired, then you could recover loss of value. You will have your client testify as to the value of his property before the incident and after the incident, and then ask your client what is the difference in that value as your property damage valuation, and that's what you're presenting to the trier of fact, which is what you're seeking. You can also ask for diminished value of a certain property. If the property damage was repaired but has lost value as a result of that repair, then you can, in addition to the repairs, getting the property damage estimate or bills presented, you can also present the value that was lost, which is the diminished value, and seek that from the trier of fact as well. There is something in civil law known as the collateral source rule. And what this says is that plaintiffs own medical, disability insurance, employee benefits, governmental benefits, none of that stuff that we expect people to seek out for their own protection, insurance and such, that's not going to work to reduce the plaintiff's recovery of their compensatory damages from the defendant. After all, why should we punish the plaintiff for being responsible in seeking this protection for themselves in life? For instance, at our firm, we practice, I told you guys, we practice auto subrogation, right? So this means that our client, who is the insurance company, they will pay to the insured for the damages and the injuries that the defendant caused to the insured, right? But the defendant failed to pay them for whatever reason, whether it's because they didn't have insurance, they were uninsured motorists, or because their insurance company has denied our insured's claim. So then what we do is we pursue the defendant to recover the monies that our client, the insurance company, actually paid out in the name of the insured. So when we go to court, we ask the judge for a motion in limine to keep out the mention of insurance under this collateral source rule, because after all, that's what the rule says, right? Because the position is, if insurance is mentioned to the jury, then it's highly likely that our case is going to be prejudiced and that the jury is not going to want to award damages, since the named plaintiff, i.e. the insured in our case, has already been compensated, right? They've already been compensated, and we're pursuing on behalf of the insurance company. Well, a lot of people don't like insurance companies, and they think, well, we don't want the big bad insurance company to be compensated. Who cares? They can bear the loss, right? Well, that's not how the law works. So that's why we have this collateral source rule. And so it keeps out the mention of insurance and of compensation that the plaintiff has gotten, because after all, the defendant is still responsible for their actions, right? Just because, again, the plaintiff was responsible and they went out and sought insurance for themselves, that doesn't mean that we are going to punish them or we're going to punish the insurance company because of this. So that's the reason why we have the collateral source rule, and in subrogation we use that to our disposal. There's also something known as mitigation of damages. So at the same time, we don't want to punish a plaintiff for being responsible, but we also hold the plaintiff to certain responsible standards, or we hold them to standards in which we expect them to be responsible for themselves. So avoidable consequences, also known as mitigation of damages, you will hear those terms interchangeably. Those are closely related to contributory negligence, and it states that the plaintiff's recovery will be reduced by the amount of damages that the plaintiff could have avoided by reasonable conduct. For instance, promptly seeking medical care and following medical advice after suffering an injury by the defendant. It's tied into contributory negligence because you will learn down the line in personal injury that a plaintiff, like the defendant, is expected to use reasonable care to avoid injury to him or herself. Then, if the plaintiff fails to abide by this standard, we say that the plaintiff failed to mitigate his or her own damages and can't pursue the defendant for his or her own negligence. It only makes sense. Let me give you guys an example. This is an example actually used in my personal injury class. The defendant negligently threw a baseball through a large window in plaintiff's living room, shattering the glass. Then plaintiff unreasonably fails to seal up this broken window to protect the room from, adverse weather conditions. Consequence to the defendant's tortious conduct, throwing that baseball through the window and breaking it, plaintiff's very expensive antique furniture was ruined because it rained. Okay? So, defendant here, in this scenario, is liable for the broken window because he or she was negligent and threw the baseball, and so we say, well, defendant, you're responsible for that action, most definitely. However, the defendant is not responsible for the damaged furniture under mitigation of damages or avoidable consequences, because the plaintiff, after suffering the tortious conduct by the defendant, failed to take reasonable actions to protect him or herself and did not seal up that broken window. And so after that action, the room's contents, the furniture, was ruined. So we're not going to hold the defendant responsible for that because the plaintiff could have mitigated those damages. The plaintiff can't just do nothing and just allow any and everything to happen after the defendant has committed some kind of tort on them. we have to draw the line somewhere. And again, you'll learn in personal injury about proximate cause, but at some point in time, we have to draw the line to defendant's liability, and this is how we do it, with expecting the plaintiff to mitigate his or her own damages. And if they have failed to do so, then we are not going to hold the defendant responsible for those damages. Courts have long awarded emotional distress damages in claims when the plaintiff has suffered a direct injury. We just talked about that. That makes sense. That's part of the compensatory damages. And we said that if the plaintiff is injured and as a consequence to that injury has suffered pain and suffering, then we are going to hold the defendant responsible for that, right? So plaintiff was involved in a car accident, was hurt, he could recover his medical expenses as well as the money for pain and suffering that he also endured from those injuries. That's known as the impact rule. Emotional distress damages are added on if the plaintiff suffered a traditional physical contact from the defendant's negligence. But what if the plaintiff's spouse, for instance, witnessed that car accident in which the plaintiff was injured? Could that spouse recover emotional distress damages as well? Depends on your jurisdiction. Some say yes, some say no. Some say that you could recover for emotional distress if it leads to a physical injury. In Texas, for instance, under the bystander cases, there are cases that involve emotional distress because somebody has witnessed a loved one being injured or killed. So in Texas, for instance, in our jurisdiction, it's recoverable if the injury from the emotional shock was a foreseeable consequence of the negligent conduct. And if there was, it's usually restricted to family members. So it just can't be any bystander. It has to be somebody that is closely related to the person that was actually injured. Okay? So you have to look at your jurisdiction to determine whether or not emotional damages from bystanders would be compensable. So they're not always going to be. Another one that is going to be case by case, jurisdiction by jurisdiction, is loss of consortium. Loss of consortium refers to the impairment of a relative's opportunity to relate to the party directly injured by the defendant. Classic loss of consortium case is brought by a spouse of a person whose physical injury has now prevented him or her from enjoying the usual satisfactions of a marital relationship. And everybody always thinks that this is just sexual relations, and it's not. Under loss of consortium, it includes, the recreational activities that the couple shared previous, the division of labor within the household that the injured plaintiff cannot partake in anymore. It includes sexual relations, comfort, affection, advice, moral support that flows from the marriage. Those are all included under loss of consortium. And like I said, this isn't compensable under all jurisdictions, so you have to look up your jurisdiction to determine whether or not it is. And then there are some states that have it for spouse, but they won't have it for, say, parents. Parents will try to pursue loss of consortium for the loss of their child from their injuries, or vice versa. Children will try to pursue it for the loss of the parents. In Texas, we have for the spouse loss of consortium, but not for the parent from the child's injuries. Now, one important question to ask during discovery in interrogatories or during a deposition is about the plaintiff's prior injuries, because these can be used to attack the plaintiff's current claims of injuries. It's actually a great way for the defense to discredit the plaintiff's injuries by allocating the blame to the prior injuries. So it's very, very important, if there are any prior injuries, those that are closely related to the current injuries, for you to investigate those and make sure that they're not related, and seek out expert witnesses that are going to testify to this, because you better believe the other side is going to bring forth evidence that is going to show that these are closely linked. Punitive damages. Punitive damages are another form of damages. Oh, I'm sorry, you guys. Before we get to punitive damages, it looks like I've skipped a slide here. Bad faith damages. Bad faith damages you will usually see brought up in insurance cases. because there's a deal that you have between you and your insurer, and that is that you agree to pay your premiums on a regular basis, right? While your insurance company agrees to pay you when you need to be paid out, right, for possible injuries. By entering into that contract, the insurance company accepts a good faith duty to carry out its obligations to you. Any type of breach of this contract can potentially be considered bad faith, in which you can pursue bad faith damages against an insurance company. And the types of conduct that may be considered bad faith are claim denials by the insurance company, payment delays, insurance broker or agent misrepresentation. Those are among the most common. Your book also gives the example of a party bringing suit for harassment purposes. For instance, if this is the case, then there may be bad faith damages that can be awarded as well. Now, there are some forms of compensation that go beyond just trying to make the plaintiff whole, as we say, and get into a more punishment-like state of tort law or civil law, something that actually overlaps with criminal law. And the punishment, so to speak, is the award of punitive or exemplary damages. And these are awarded to deter especially malicious conduct on the part of the defendant. Putting a stop to punitive damages is a major factor in tort reform in every state. The latest tort reform law in Texas took effect September 1st, 2003, and limited the damages for pain and suffering in most medical malpractice cases to only $250,000, less than that for public hospitals and public doctors. Texas is one of 31 states to cap damages. There's no limit to economic damages like reimbursement for medical bills or lost wages. However, there is this cap for pain and suffering. And again, the reason why was because you guys have probably heard years and years ago about the outrageous amount that some plaintiffs were awarded in civil cases, from tobacco companies or doctors, pharmaceuticals. So that's the reason why there was this push for tort reform. And some would argue that they have really just gone the other way. I mean, putting that $250,000 cap is not going to really compensate or make a plaintiff whole or punish the defendant for such egregious conduct as killing a patient on the table after they've gone brain dead because of some negligence on the doctor's part. So that's debatable, of course, but again, punitive damages is something that is still allowed today, although there are those caps. So you have to look at your jurisdiction to see what the caps are in your state. Nominal damages, these are awarded in situations where no actual damages have occurred or the amount of injury hasn't been proven even though a right has been violated of a plaintiff in an intentional tort action such as trespass cases, for instance. So in these cases, the court might award $1 to the plaintiff, to the winning party, as a symbolic gesture or as a matter of principle. A lot of times that's what the plaintiff is seeking. Just as a matter of principle, I am seeking this defendant and spending all this money, and so long as I get this award, then I don't really care if it's nominal or not. I have won after all. Equitable remedies. So sometimes a party's not looking for a win based on principle or symbolic gesture, such as in nominal damages. In fact, they're not seeking any money damages at all. In cases of nuisance, for instance, which is a civil law case, and this is a nuisance, you guys will learn in personal injury class. It's an unreasonable or unlawful use of someone's real property that injures another person or interferes with that person's use of their real property. The usual judicial intervention in these cases is an equitable remedy, is either an abatement or an injunction. The court will enjoin the defendant to either cease or limit its activity, and that's what an injunction does. It asks the defendant to either stop what they're doing or limit what they're doing in some way, shape, or form. Declaratory judgments, these give a party a partial judgment, so to speak. You could obtain a final determination of certain facts from certain parties and save other issues for trial. For instance, if I have a lawsuit against two parties, but only one of those parties has filed an answer, I can obtain a declaratory judgment against the defaulting party, and then I could pursue the responding party at trial. So that's how you may be able to get a declaratory judgment, or you can do it on certain issues as well against the same defendant. In cases where a party may need immediate action from the court may allow that party a TRO, a temporary restraining order, as an equitable remedy. TROs are often granted in family law cases, namely domestic violence. And the usual purpose of a TRO is to maintain the status quo or freeze everything until a hearing can be held so that a judge can listen to the evidence and make his or her decision. Now, two of the most important factors to consider in a civil lawsuit is, can I prove this defendant's liability? And if so, does the defendant have the ability to pay my judgment? Proving defendant's liability focuses on the facts of the case along with the credibility of your client and his story. If your attorney believes that liability is probable, then he's going to want to conduct an asset search on that defendant to determine whether or not the defendant can satisfy a money award. Because if he does conduct the asset search and it proves futile, there are no assets that the defendant has to pay or to satisfy a judgment award, then that judgment is really worth only the paper that it's printed on, which is nothing, okay? You've got what we call a judgment proof on your hand, a judgment proof defendant on your hands. He's judgment proof because even with the judgment, you can't squeeze the funds out of them. You know the saying, you can't get blood out of a turnip, right? So if you do conduct the asset search to come up with nothing, then you're probably not going to want to pursue that defendant unless you're seeking nominal damages or some kind of equitable remedy, because he's not going to have any money to give you. And think about it, if you don't pursue that asset search and you're going along and spending all this money in litigation thinking that you're going to get some kind of money damage award down the line, and then you find out after all that effort and work and money and time that the defendant doesn't have anything, then, you know, you're, again, sitting on nothing. And it's going to be a huge, huge disappointment after all that time and money that you spent. So it's very, very important, very, very smart from the outset for attorneys, for law firms to conduct these asset searches to determine whether or not the defendant can actually pay or satisfy a money judgment down the line. To conduct a basic asset search, you're going to want to turn to public records, such as real property searches. You could look at the home appraisal district websites, for instance, DMV search for vehicles that are owned by the defendant, search for fictitious businesses, DBAs, doing business as, search through court records for bankruptcies and such. You can do this yourself. There are so many public records that you could turn to, or you can also hire a company to conduct the search for you. But whatever it is that you decide, it definitely needs to be done, again, so that you can determine whether or not you want to, in fact, pursue this defendant, this cause of action against the defendant. Finally, the jury is going to get some instructions about the case, as we discussed in the last class, and then they're going to deliberate, and they're going to come back with a verdict of liability and a possible award of damages. There are some times, though, we've talked about this, that the jury's role is going to be allocated to the judge. So that is known as a bench trial. If there is no jury fee that is paid by the defendant or either party, there hasn't been any kind of request to have a jury hear this case, then you will have what's called a bench trial, okay? And this is where the judge comes in and acts as not only the judge and determines questions of law, as we've talked about, because that's their role, but they're also the trier of fact. They're the fact finder now. We talked about this a little bit before as well. So they will step in to the shoes of the jurors, and they will consider alone whether or not the defendant is liable and to what extent they are liable. So that is Chapter 11 and the issue of damages. The next chapter that we're going to talk about is Chapter 12, which is arbitration, mediation, and settlement. This is all under the umbrella of ADR, which is Alternative Dispute Resolution. And it is just as the name or the term or the title suggests. It is an alternative way to resolve disputes. And paralegals are becoming increasingly involved in assisting their attorneys and clients in preparing for alternative dispute resolution, or ADR for short. The interest in and use of ADR is continuing rapidly because ADR keeps many cases out of an already overcrowded court docket, and it really does relieve the pressure on the courts and the parties that are involved because, like courts, parties don't want to have to wait years for their case to be heard, right? So if there is some sort of alternative way to resolve our dispute, then we're going to take it. We're going to try anyway. ADR takes less time. It's less formal than trial, so it saves parties money, which is always a good thing. One last thing about ADR is that its process is less adversarial. It's less controversial than trial is, and it may substantially reduce the emotional trauma that is associated with trials. I don't care how many times we have cases that go to trial. The parties that are involved in that litigation in those trials are carrying a heavy burden. We've talked about this in I&I several times, right? And there is emotional trauma that is attached to this. So there's people's, livelihoods, their jobs, their lives, their children that are at stake in litigation and trial. And so if we can effectively reduce all of that trauma, all of that money, all of that time, all of that effort, all of that work, and again, resolve it in some other fashion, then why wouldn't we do it? So there's several different methods of ADR. One method is arbitration. Arbitration is an ADR process consisting of the submission of a dispute to a neutral decision maker known as an arbitrator. So an arbitrator, it determines the party's rights, liabilities, and remedies. And it is analogous to a trial, and the arbitrator will give you a decision analogous to a court decision, okay? So it's binding. It's binding on the party. Arbitration process is used most commonly in contract disputes. In fact, many contracts will contain a clause requiring the parties to resolve any serious disputes that arise under that contract through arbitration. So if you look through your cell phone agreement or your credit card agreement, you are very likely to find an arbitration clause within it. Hence, by signing that contract, you have agreed to arbitrate your disputes with that company rather than pursuing your case in a court of law. So arbitration is very important. It's very commonly used, and again, it's in lieu of going to a courtroom, going to a court of law. And unlike mediation, which we'll get to in just a little bit, arbitration, like I said, is binding. So the arbitrator's decision is akin to a judge's. His decision is binding on the parties and can only be appealed to the courts under very limited circumstances. For instance, if the award is obtained by fraud or corruption, if the arbitrator was obviously partial, was biased, or was corrupt, if the arbitrator was guilty of some kind of misconduct or some obvious abuse of fairness or discretion, then there may be an appeal made from that decision as well. This is a list of issues that are commonly brought before an arbitrator: medical malpractice issues, both medical and legal, disputes between contractors and third parties in highway construction, negligence claims against state highway system, wills, torts, also the construction of a statute, statutory claims, spousal support payments, the effect of bankruptcy on other issues. There's also some issues that may be inappropriate to bring forward in arbitration. The right of a person to enter into a profession, whether it's law or medicine, custody and visitation rights of minor children, interpretation of the state or federal constitution, an action based on a criminal enterprise or invalid contract. Those issues will never be brought before an arbitrator and can only go before a court, in a court of law. The procedure in arbitration is initiated by a demand for arbitration or a statement of claim. And this document sets out the dispute, a remedy, and the award or the amount of award that is sought. It serves the same purpose as a complaint, but it is generally more informal in nature. The demand is usually accompanied by a submission agreement that is signed by both parties agreeing to the arbitration. There's a list of arbitrators that are sent to the parties who can select an arbitrator from that list. You know, you can't select your judge, for instance. Form of discovery is also available in arbitration, and then there's a hearing date that's set. And the hearing is similar to a trial, but it's more informal. There's opening arguments, witnesses are heard, some cross is allowed, and evidence is presented. But in all cases, rules of procedure, rules of evidence are very, very much relaxed. I have here a video. Again, we're going to take a look and see if it plays, of an arbitration.
Here's the situation. Miss Smith.
Okay, so hopefully you guys were able to watch and listen to that video. Just a short little snippet giving you a little glimpse of what an arbitration might, or how it might go down. But that's basically it. So it is pretty similar to a mediation, and both of them, both arbitrations and mediations, are very, very, very relaxed and simple forms of what a trial would be. But again, trials are much bigger and more formal, and you've got all the rules that go with it, and these are just a lot more relaxed. So alternative dispute resolution arbitration. Mediation is an ADR process that incorporates a neutral person called a mediator. And that mediator comes in and facilitates a mutual resolution of the dispute between the parties. The mediator, unlike an arbitrator, cannot dictate an actual decision. So the mediation is not binding on the parties. Okay, what mediation does is it focuses on common ground and tries to come up with a compromise to resolve the dispute. State judges strongly favor mediation. There's this justice of the peace that I go to many Monday mornings, and what he does is he makes all the parties mediate before they go to him for a bench trial. So he's got a whole team of mediators there, and they're all volunteers, and nobody's getting paid to be there, but they're there to help the parties to resolve their disputes. And it is very highly successful. I was very skeptical when he first started doing that, but you know, about 90–95% of my cases do settle in that informal mediation that he sets up. So again, judges strongly favor mediation. I actually have another video of a judge talking about mediation and how much they favor it. Mediation is the answer. And that justice of the peace that I go to has a very similar outlook, and he will give his little spiel in the beginning to the whole courtroom, and he will say something very similar. I am instructing you all to mediate, and by participating in mediation, you guys have a hand in the outcome of your case. When you come before me, I will only look at the facts of the case and the law. I will apply the law. One person usually gets everything, one person loses everything. In mediation, it's a compromise. You guys can come up with a resolution to your conflict yourself. It's a wonderful thing. And he also instructs the defendants that they will not have a judgment on their record if there is an agreement in mediation. However, if he rules against the defendant, then there will be that judgment, and they'll have to contend with that, whether they go apply for a job or in their credit report, things of that nature. So mediation is a very, very powerful tool. You could choose your mediator. Many times the judges will have a certain mediator that they will suggest that you use. They'll have a list of mediators for the parties to choose from. If money is an issue, there are also dispute resolution centers that are free or will charge a nominal fee for mediation. The ones that are conducting the mediation are volunteers. They're not paid for their time. Usually they do that because they're trying to acquire the number of hours that they need to become certified, or they're just trying to get experience. And so that team of mediators that Justice of the Peace that I was telling you guys has are from the DRC, Harris County DRC downtown, and they are all volunteers, like I said, and they don't get paid for their time. So it's a wonderful thing to have them there. The parties that have to be present at the mediation are basically those that are directly involved in the case, the parties, and the attorneys, and then those that have full settlement authority. So in our case, for instance, the insurance company representative, many times in our mediations, because we do auto subrogation, they're allowed to be available by phone, but there are some mediators that do not allow that, and they have to have them there, so we will have them there at the mediation. The mediator controls the mediation by laying out all the groundwork for all the ground rules for the parties. Plaintiff will usually go first because they're the ones that have brought the lawsuit. They'll start with a very short opening statement followed by the defendant. The mediator will usually ask questions from there, possibly asking for proof or evidence for visual aids. Remember, they're not dictating any kind of decision. They're trying to gain an understanding of the strengths and the weaknesses of the case. Because remember, this is a non-biased party, neutral party that's coming in, and they're just going to let you know, hey, you know what, it looks like they've got this on you, but it looks like you've got this in your favor, maybe it's best if you think about settling, etc., etc. So then the parties will continue discussing as a group, or they may be caucused out. They'll be separated by the mediator, where the mediator will have them in different rooms, and then the mediator will shuffle between the rooms to talk to each party individually. All conversations in mediation are confidential unless the party indicates to the mediator that information can be shared. You will continue like that. Sometimes you've got a full day mediation, 8 hours. Sometimes half day mediation, which is 4 hours. Sometimes, mediations can last, 20 minutes. But you'll continue on like that until you reach a settlement. If you reach a settlement. If no settlement is reached, then the mediator will declare an impasse, and they will write a report reflecting the same. And then you'll go on and go to trial because you've reached that impasse. So now that we've talked about mediation, let me give you guys an example of what this looks like in real life. Okay, one thing that the video said was that an apology can sometimes spark settlement talk. Sometimes an apology is really all a party is seeking. So mediation is great in that, again, it brings the parties together and it helps facilitate a conversation. It helps them to communicate with one another, because oftentimes what happens during litigation is they are adversaries and they are acting as such, and so they don't want to put their guard down because they expect that that's how they're supposed to play the game, so to speak. And so mediators help to relax the parties and, again, help them to communicate with one another. And sometimes, like I said, especially in family law cases and whatnot, that's really all the party is seeking. And so you'll come out of mediation and the case is over and done with because that party got an apology. Not most of the time, but sometimes. Cases can be settled without mediation or arbitration. In a settlement agreement, the defendant will usually agree to pay the plaintiff, and in exchange, the plaintiff agrees to dismiss the lawsuit. The dismissal can happen with or without prejudice. So there's two different types of dismissals. There's one with prejudice and one without. If you file the dismissal with prejudice, then you can't refile the lawsuit. But if the dismissal is filed without prejudice, then you can refile the suit if the statute of limitations has not run on that case. Now, after that, Justice of the Peace in the court that I was telling you about, after he receives the mediated settlement agreement from us, he will read it aloud to the parties, make sure that all terms are satisfactory, because a settlement agreement is analogous to a contract and has to possess all the same requirements. So the judge will ask whether both parties know and understand the agreement, both sides have the legal capacity to enter into this agreement, i.e. they're not minors, mentally incompetent persons, somebody who's under the influence that can't enter into the contract. Mediations, you know, they're not going to be successful unless there's consideration between the parties. Again, this is part of your contract. Plaintiff also, like I said, agrees to drop the lawsuit once the defendant pays the agreed amount. That is the consideration. There are literally, you guys, millions of lawsuits that are filed every day, but the vast, vast majority of those lawsuits will never see the inside of a courtroom because they settle. In fact, cases can settle at any point in time during litigation or pre-litigation phase. So if you get a case and you find favorable evidence in your file for your side, then your attorney will get on the phone with the other side and try to settle with them before even filing suit. However, on the other end, your case can go all the way to a jury trial and then settle. I had a case where I went and we were about to go through voir dire, we were about to question the jurors, and the judge called me and opposing counsel back to chambers and asked us whether or not we had tried to settle the case, and we had, and we were actually pretty close. And he said, you guys are not going to waste the court's time. You're not going to waste those jurors' time. You guys are going to get on the phone and basically made us settle the case, and we did. So again, settlement can happen at any point in time. One very impactful source to move towards settlement is to present the opposing side with a settlement brochure. The brochure illustrates or highlights the strengths or weaknesses of your case, but also paints a picture of what the jury will see in the case. Today, these brochures are done through video, and again, just like the video that we saw before, it can be very, very impactful to show the other side the contents of what your client is going through to help them settle it. You know, again, it gives them a view of what the jury is going to see. If the jury sees all this, then it's likely that they're going to get a higher reward or award than they are probably going to settle for. I advise our insureds all the time not to sign a release unless they read it over first, or we read it over first, because a release releases, as the title suggests, all claims against the defendant. So unless the case has been settled, this is not something that you want to sign. Parties can be very, very sneaky when it comes to releases and the language that they put in there. So you want to make sure that even after you've settled, that the release is only referring to the actual settlement of the issues that are between those certain parties and doesn't encompass all other issues or all other parties that may bring forward a litigation against the defendant. So that's what I have for you guys for Chapter 12. That is alternative dispute resolution. Again, looking for alternative ways to resolve our disputes through mediation, arbitration, or just settling the case through negotiation of the other side. So if you guys have any questions for me, this is actually our last class done via recording, but it's our last class, so I will not see you guys again. I will not see you all next week. You will be starting a whole new term of classes, but thank you again for being a wonderful class and participating. I really, really enjoyed our time together, and if you have any questions for me, then please feel free to email me and let me know. Other than that, I wish you guys a very, very best of luck with your next set of classes and in your careers. See you guys soon. Thanks a lot. Bye.